Afternoon, folks. This is Chapter 7, Part 2, that we're going to be looking at the Fifth and Sixth Amendment rights to counsel and other rights under the Fifth Amendment. Give me one moment. I'm going to pull up the slide deck so we can continue to use those. All right. So we're now at the Fifth Amendment. And before we start, I just want to talk a little bit about what we did last week, talking about Fourth Amendment protections against unreasonable searches and seizures. You've had an opportunity to look at the cases, and you've had some opportunity to write a little bit about your thoughts about those cases, and sort of just a final thought about that first part of Chapter 4. Of Chapter 7, is I think you're already now getting a little bit of a taste of kind of how difficult it is for the police officers to kind of keep all of this law straight, and that there's very little what we call bright line or black letter law that makes it really, really easy for the officer to apply on the street. The officer has to be kind of up on the law and up on the concepts so that when they're faced with different facts, they can apply those facts to the law appropriately and correctly. So I'm hoping that you now have some what we call empathy for the sort of task at hand on the street when the officer is trying to apply all of this law. Consistent with that, now we're moving on to the second part of 7, and this is all the same kind of law that the police have to apply correctly and perform correctly. The Fifth Amendment protects against self-incrimination. So we see that on TV all the time where people are saying, like, I plead the Fifth. And what they mean by that is they're saying that whatever the question is that's asked of them, the answer would have a tendency to incriminate them. And under the Fifth Amendment, people are not required to provide evidence against themselves. There are some exceptions, right? And the exceptions are, it's really that you're not being required to testify against yourself. So you can be required to provide blood samples, handwriting exemplars, because it's not testimony, and you can be required to provide that without being in violation of the Fifth Amendment. Similar to the suppression and the idea behind suppression was when we came up with the exclusionary rule. That was, as I indicated previously, you can't find that rule explicitly in the U.S. Constitution because it doesn't exist. This is judicially created law. It's intended to be a protection for the individual against the state, that exclusionary rule. Similarly, when we watch TV, we hear about people's Miranda rights, that people have to have their rights read to them before they're interrogated by the police. So we're going to spend some time on this. First and foremost, beside to the right of you, you've got the link for Miranda versus Arizona, and I want you to read that case and do it the same way that we discussed last week, which is you're going to highlight it, copy it, move it to your URL, paste it into the URL, and then that case is going to come up and you get to read it. Miranda is a really, really important case. It is the case that says that if someone is taken into custody and they're being interrogated, both of those have to exist, interrogation plus custody, the police are required to read them their Miranda rights. So I want to spend a little more time talking specifically about those rights, and and what the rules say, right? First of all, there's really two primary rights. Sometimes you'll hear people talk about there's 4 primary rights. It's really 2 and some qualifiers on those 2. The 2 primary rights is that you have the right to remain silent. Okay. The second primary right is that you have the right to have an attorney present while you're being interrogated. The sort of sub rights, or the second and fourth rights, as you hear it on TV, is you have the right to remain silent. Anything that you say can be used against you in the court of law. You have the right to have an attorney present while you're being interrogated. If you cannot afford an attorney will be provided for you while you're being interrogated. So that's sort of the 2 main rules with the sub rules. There's no magic to that language. It can be told to the defendant in any order, and the words are not specific. It doesn't have to be written. It doesn't have to be signed. It doesn't have to be recorded, but it does have to be done, right? So when we teach police officers, we teach them, you should have it on paper. You should have them check off or initial each right that they understand the right, have them sign at the bottom that says that they understand the right. They do not, the police are not required to say, although you see it all the time, the police are not required to say, having these rights in mind, are you willing to waive those rights and speak to me? The police officer could read the rights and then just start asking them questions. And if the defendant answers the questions, it is deemed to be a constructive waiver of Miranda. So you see those warnings read to a defendant, and then the police officer goes directly into, what's your full name? Where do you live? Who do you live with? Do you have siblings? What are their names? What do you go to school? Did you go to school? Where do you work? All those kinds of what we call demographic questions. You're answering all those questions, and then they dive in to asking questions about the crime that they're investigating. All that's going to be deemed a waiver of Miranda, and the officer will have satisfied what they were required to do. The reason why Miranda exists is the same reason why the exclusionary rule was put into place, was that there was a concern back in the early 60s. There was a concern that that the police had gotten really, really good at getting confessions. And the concern, again, I'm not sure how much of that was evidence-based or evidence-informed, but the concern was that the police had gotten so good at getting confessions that they were getting confessions from people who didn't actually commit the crimes. And it was a recognition, and I don't want to be overly abstract about this, but I think you folks will be able to relate to this. You're driving down the street. You're driving, the speed limit's 35 miles per hour. You're doing 35 miles per hour. Other cars are blowing past you. And you look in your rearview mirror and there's a police car right behind you. Does your heart rate go up or does it go down? Well, for most of us, our heart rate goes up. And the question is why? If you know with absolute certainty that you have not violated any laws, you're driving the speed limit, and there are other people around you clearly not driving the speed limit, why does your heart rate go up? And the reason why is what has been described as the inherent coercive nature of police-citizen encounters. That people, non-police officers, when they come into contact with police officers, feel like that they have to do what the police officer tells them to do, that they must comply, and that they have no choice, right? So the thinking behind requiring the Miranda rights read to people is reminding them that they have these rights, that they actually can invoke those rights to protect themselves. And we could literally spend a separate class talking about whether or not Miranda has paid its way, whether or not it actually has resulted in less coercive interrogations, whether or not people are actually invoking those rights when they probably should invoke those rights, that sort of thing. So Miranda warning must be given before interrogation for any offense when a person is in custody. So this is really, really important. The idea behind Miranda is to deal with investigation. It does not deal with the situation where someone's already been charged with an offense and all the things that occur after they've been charged. This is investigation stage. This is the police officer walking up to you and saying, will you come to the police station and answer some questions? And if you say yes, and you go there, then you need to make some decisions about whether or not you're being seized. If the police officer doesn't ask you for permission, they just say you have to come to the police station, answer our questions, you've got the first prong of Miranda, which is you're now in custody, right? So custody is important. Custody must be present. It's two things: custody plus interrogation. Interrogation is questions or actions by the police officer intended to elicit an incriminating response. You have to have both. You're going to see all kinds of fact patterns where the police officer is interrogating someone in a bar. But if you're at the bar voluntarily, then it's not custody, and therefore Miranda is not required. It'll look a lot like a situation where you think Miranda would be required, but if it's not, if they're not in custody, then Miranda is not required. You have to have both custody interrogations. Similarly, you'll see another situation where they're actually in custody and there's really no doubt they're in custody, but the officer's not actually asking them any questions, right? So you got to make sure that you're listening for either words or actions on the part of the police that are intended to elicit an incriminating response. So when you read that Miranda, the prompts that you're going to get are going to ask you some questions about whether or not you think Miranda actually works, whether or not people who hear the Miranda rights are more likely or less likely to assert those rights and therefore not talk to the police without those rights being invoked. So what constitutes questioning or interrogation? Interrogation takes place when police officers ask direct questions. That's the easy one. The officers asking direct questions related to some kind of a material fact that's about the crime or really any crime while they're in custody. But not name, age, address. Just because the officer's asking you questions doesn't mean that's interrogation. You have to listen to the kind of question and see whether or not it's asking them questions that are intended to elicit an incriminating response. Sometimes the police officer is not asking a question, but what they'll do is they'll say things. They'll say like, yeah, we talked to your buddy Bob, and Bob told us all the things that you and he did. That's not a question, but it is a remark made by the police, and it's made with the intention of trying to get you to respond to it. So when police officers make remarks designed to appeal to the defendant's sympathy, religious interest, so sometimes you'll see something like police officer will say something along the lines of, I'm not asking you any questions, but I gotta tell you, man, it's snowing outside and there's a family out there. They would really like to get their loved one back so that they could have a good Christian burial. I'm not going to ask you about what you did, but we really need to know where that body is located. Those kinds of things where they're not asking something specifically about the crime, but they're trying to get the defendant to make an incriminating response. That's going to be deemed to be interrogation. There are again, at the beginning of part 1 of chapter 7, we talked about how there's aspects of the law that's dynamic. Interpretations of the constitutional law change, are enhanced, modified, increased over time, and we see that specifically with Miranda. So Miranda came out in 1966. And since that time, there's been lots of modifications. So, second interrogation after the suspect initially refused to make a statement. So, officer reads the Miranda, The defendant says, I'm not talking to y'all. The police says, fine, and they walk away. And then after some substantial period of time, they come back to the defendant and said, you said you didn't want to answer our questions. Let me read you Miranda again. We've got a little bit more information about the case. This is your big chance. And he says, okay, fine. And they said, let me remind you of your Miranda rights. He waives Miranda rights and then makes a statement. The fact that the first statement, the defendant refused, if the defendant refuses by saying, I don't want to say anything to the police can come back after a break and ask them whether or not they've changed their mind. The difference being is of the two rights, right to remain silent, the right to have an attorney present. We never see this on TV, but the most important right is the right to have an attorney present. If the defendant says, I need to have my attorney present before I speak to you, all questioning ceases and the police cannot reapproach the defendant even after a break of time. They can't approach the defendant unless the defendant initiates contact with the police. On the other hand, if the defendant says, I wish to remain silent, the police officer can say, fine, I'm going to leave you. And after a break in time, they can come back and say, I know you said that you didn't want to speak, but let me tell you about what I know about the case, see if that's changed your mind. All that's perfectly okay. Voluntary statements made by a defendant, even if they're not rational. In other words, and even if that's a statement they should not have made, and no reasonable person would have made it, if it is a voluntary statement, in other words, the police didn't use any kind of coercion to get them to make the statement, they're admissible. Oral statements voluntarily given are admissible, right? So statements made in the back of the police car where the police officer is not asking any questions, but the defendant is clearly in custody, those oral statements are admissible. As I indicated previously, the rights do not have to be given in an exact form. This next one, police may continue continuing questioning after ambiguous requests for counsel. There is a whole avalanche, laundry list of cases out there that deal with that situation where the defendant, when they're being interrogated while they're in custody, is not actually saying, I'm not talking to you without a lawyer. They're saying things like, hey, you think I need a lawyer? Or my mama told me I should have a lawyer. Or, gosh, I don't know. I don't know. Maybe I should have a lawyer. All of that is deemed to be what we call equivocal, which is a fancy word of saying it's not an exact demand for a lawyer. So when you're listening to these things, you want to watch closely for an exact demand for a lawyer. Police officer reads the Miranda rights, the defendant doesn't say anything. The silence is not an invocation, or it's not them saying, I want to assert the Miranda rights. It's not. It just isn't. It maybe should be, but it's not. Give me 1 second here. Yep. Hold on 1 second. Let me just check one thing here. This one. My question that I'm looking at is whether or not I set it up to record. Give me 1 second. Yeah, we're recording. Sorry about that. We'll get right back to it. Yeah, there we go. Back to screen share. Back to the PowerPoint. Yeah, sorry about that delay. Just wanted to make sure that we were properly recording. Okay. Yeah, so you would really want to listen very, very carefully about whether or not they're actually asking for the lawyer. And in the same way that silence doesn't invoke Miranda, if the defendant answers questions after the Miranda rights are read, then it's deemed to be a constructive waiver. Entrapment is I'm not going to really spend a whole lot of time about that, but it's basically entrapment is a situation where the police officer gets someone to, get someone to do something that they were not inclined to do on their own. And the best example I can give you is a low-level drug dealer comes into contact with an undercover police officer. And the undercover police officer says, yeah, I really enjoy the business that we've had together, buying, $40 amounts of heroin, but I really, really, really want to get a whole lot more. And the suspect says, look, I don't deal in large amounts. I really can't help you with that. And he was like, and the police officer says, man, I'm just telling you, I will pay a premium price if you can figure out a way for me to get a couple of kilos. And the defendant then says, look, dude, there's just no way. I don't know the people that I get my stuff from well enough to be trying to get that amount. And he's like, well, why don't you go ask them and see whether or not you can convince them to sell me a couple of keys. So you see what I'm saying is this is a situation where the police officer is generating the idea of moving that level of drug. And if that idea of moving that level of drug doesn't originate with the defendant, then the police officer suggesting it or convincing the defendant to participate in it is deemed to be entrapment. Lineups. So pre-arrest lineups, lawyers are not required to be present. Post-arrest lineups, the defendant has the right to have a lawyer present. Lawyers are entitled to be present for critical stages of criminal proceedings post-arrest. Overly suggestive lineups violate due process. Suspect can be compelled to appear before a grand jury and give voice samples for comparison with voice recording. Remember, we had said earlier that you cannot be required to give testimony to incriminate yourself under the Fifth Amendment. This is a similar situation where there's an exception to that is that having someone speak, just the sound of their voice is not deemed to be a violation of the Fifth Amendment privilege against self-incrimination. Right. So that's the Fifth Amendment right to counsel. It's important for you to focus on. I want you to, after you read Miranda, I want you to think about like I said, whether or not you think Miranda has really paid its way, whether it is viable today, whether people have a tendency to invoke their rights after having them read. Very, very important for you to understand that the Miranda rights are a Fifth Amendment right to counsel, right? And that you have those two things that have to be present: custody and interrogation. And it applies to any crime. It doesn't matter. This is investigation. So if the police officer takes you into custody and asks you about any crime, it's not crime specific. And the reason why that's important is because the Sixth Amendment right to counsel that we're about to speak about is crime specific, and it's very crime specific. So you want to keep them straight. Think about Fifth Amendment right to counsel is applying before someone's been charged. After someone has been charged, a different kind of right to counsel exists. Fifth Amendment right to counsel is intended to protect the individual against coercion to give confessions. It has nothing to do with whether or not the suspect has been arrested. Sixth Amendment right to counsel that we're about to discuss is the right to counsel to defend the individual against the vast power of the state after the defendant has been charged with a specific crime. So this is the right to have counsel at trial, sitting at the trial table and defending against the state. So, Sixth Amendment right to counsel. You've got a number of cases here that you can have a look at. Powell versus Alabama, Gideon versus Wainwright, Argesinger versus Hamlin, Escobedo versus Illinois. There is one specific case that may or may not be there, but I'm gonna tell you about it. I'm gonna have you read it, which is Montejo versus Louisiana. But each of these sort of tells you, in these cases tells you about what your right to counsel is after you've been charged. So right to counsel in a capital case. Capital case is a case where the potential punishment is death. Right to counsel in a felony case, Gideon versus Wainwright. Right to counsel in certain kinds of misdemeanor cases. Really the rough rule that you need to keep in your mind is that if you're charged with a criminal offense that carries with it the possibility of jail time, you're going to be entitled to an attorney. And again, right to counsel when interrogated, that's relates back to the Fifth Amendment right to counsel. We threw stand your ground laws in here. I'm going to skip that. That's not something we really need to talk about today. But the Sixth Amendment right to counsel, this last case that you see to your right, which is Montejo versus Louisiana, I want to talk to you a little bit about that because it will illustrate for you the interaction between the Fifth Amendment right to counsel and the Sixth Amendment right to counsel. So Sixth Amendment right to counsel, as I indicated to you, it triggers on the initiation of formal proceedings against someone, which is a fancy way of saying that the person's been charged with a crime. At that point, they are entitled to have an attorney present. But I'm going to give you a little bit of a fact pattern that is related to the Montejo versus Louisiana case. And then I'm going to ask you to write some responses about what you think about that. First and foremost, you need to understand that all these rights that we've been talking about under the Constitution, those are individual rights. They are rights that are held by the defendant, not held by the defendant's mom, not held by the defendant's attorney. They're held by the defendant. So again, I like to use what we see on TV because that's the most relatable aspect of it. You'll see all the time a lawyer calling up the police officer that says, "I represent Bobby Jones, and he is now asserting his rights. So don't go talk to him." Well, in the real world, that conversation is meaningless, has no value whatsoever. Only the defendant can assert his rights. The lawyer can't assert his rights for him. So, police officer can't call up and say, as long as you've got my client in custody, you can't interrogate him. Only the defendant, after being read Miranda, can assert those rights. And then in the Sixth Amendment right to counsel, the defendant does have a right to have a lawyer present. And this gets a little bit tricky. So up to this point, all these rights that we've been talking about belong solely to the defendant, and the defendant can waive them or decide not to exercise those rights anytime they want. When it comes to the Sixth Amendment right to counsel, there's a case out here that's been around for many, many decades. It's called Michigan versus Jackson. Michigan versus Jackson holds that once the defendant gets an attorney, a Sixth Amendment right to attorney after they've been charged, that the police cannot go back and talk to the defendant, even if the defendant wants to talk to the police. The only person in the world who can waive is the lawyer. Now, that's got to set off some kind of bell for you, because how is it that this is a right that belongs to the defendant but can only be waived by the lawyer? So that's been an issue for many, many years. And then along comes Montejo versus Louisiana. And the quick layout of Montejo versus Louisiana is Montejo actually is originally thought to be a witness or a person of interest, right? And so the police pick him up and they take him in and they pick him up like there's no dispute that he's in custody and he's being interrogated. So they read him his Miranda out of the box. He waives Miranda. And so they're asking him lots of questions. The police literally think that he is not a suspect, but he has associates who are probably involved in this crime, which is a burglary and a murder. They talk to him for a while. He gives inconsistent statements. First, he says he wasn't there. Then he says he was there. And then he says he was just driving and he didn't have anything to do with it. So they know that he's not telling the truth, but he's not like outright confessing either. So they work on him for a while and he really doesn't give him much else. So they say, look, we're satisfied that we've got probable cause to arrest you. So we're going to arrest you on the burglary and the murder. And then they arrest him and they send him to jail. The next day, he gets an attorney from the judge. Now, I have to tell you, the way that works is, and it works this way in most jurisdictions, the defendant gets that lawyer at the general district court level, which is the level that I am a judge in. And we are not a court of record. So how Montejo gets the lawyer is unclear. We don't know whether he specifically said, yes, I absolutely want a lawyer, or whether or not the judge said, man, these are really serious charges. As a result of that, I'm going to appoint you a lawyer. We just don't know. We have no idea. So he gets the lawyer. Now, in most jurisdictions, when you get a court-appointed lawyer, maybe the lawyer comes to see you the day that he's appointed, but that's kind of an exception. It's certainly not the rule. And good lawyers will come see you within 48 hours. But most lawyers, especially the overworked ones, it may be several days before they get around to come into the jail to talk to you. So in that gap, the day after Montejo gets arrested, he gets his Sixth Amendment right to lawyer. Montejo has not seen the lawyer. The police officers pick up some additional information and they want to talk to Montejo again. Now, remember, Montejo had Miranda read and he waived Miranda, right? So one of the questions that we've always asked is if he waives Miranda and then gets a lawyer, does that waiver of Miranda waive the Sixth Amendment right in terms of allowing the police to come back and talk to him? Is a waiver of both your Fifth and Sixth Amendment rights? We weren't terribly sure about that until Montejo came along. So police officers go back to Montejo. They remind him that he waived Miranda. They also remind him that he has a lawyer. They say, when we were talking to you, you offered to ride around with us to show us where all y'all went and where all these people live and that sort of thing. And are you still willing to ride around with us? And he says, sure, I'll ride around with you. While they're riding around, the police officers say something along the lines of the speech that I told you earlier, where they're like, this family would really, really like to know what happened to their kid. It would go a long way to helping you, if you would write a letter of apology to the parents. And Montejo agrees. And they hand him paper and pen while he's sitting in the back, and he writes out a full confession. So imagine the surprise of the lawyer when he gets to court later on, and the police pull out this confession that he made that occurs after the lawyer's been appointed. Lawyer loses his mind because at that time, Michigan versus Jackson, which is a U.S. Supreme Court case, says police cannot go back and talk to Montejo after he gets the lawyer. So feels like it's pretty clear. Well, the state argues, Judge, this has just never made any sense that we have got this one right that although it belongs to the defendant, can only be waived by the lawyer. And the Louisiana court agrees and says, this has never made any sense to us. We don't think Michigan versus Jackson is good law. And it makes its way up to the Supreme Court. As a result of that, the Supreme Court says, and I think says correctly, is that all of these rights are rights that belong to the defendant, and the defendant has the right to waive them. So even though Monteo got a lawyer, um, the police can go back, remind him of his Miranda rights, and see if he still wants to talk. And if he wants to talk, then the police get to continue to talk to him, even though the lawyer may not want that to happen. So that's now the new law, that it is returned that right to a right that belongs to the defendant and can be waived by the defendant. So when you're writing your prompt here, I want you to think about a few things. I'd love to hear your thoughts about it. First of all, do you agree with this? I mean, do you agree that all these rights should only belong to the individual and are not can only be waived by the individual, or do you think that certain kinds of rights, especially once the defendant gets a lawyer, that the lawyer should be the only one that waives them? Because as we kind of know, people who get charged make really kind of not great decisions, right? And maybe because of that, we should protect them from themselves, right? I think one of the judges in Monteo versus Louisiana said something along the lines of, this is imprisoning someone in their rights and calling it the Constitution. The idea that we are gonna enforce rights even if the defendant doesn't want them. So it would be, so part of what I want you to think about is it okay for us to be that sort of paternalistic or that protective of people's rights, even though those rights belong only to the defendant? It's really saying we don't think defendants make the right choices, and as a result of that, this particular right, we're going to say only the lawyer can waive. And then the next question for you is whether or not it matters to you how Monteo got the lawyer. If Monteo says, yeah, 100% I want the lawyer, is that an assertion of your Sixth Amendment right that wipes out the waiver of Miranda? Now, I will tell you, Monteo says the waiver of Miranda waives the attorney for both Fifth Amendment right to counsel and Sixth Amendment right to counsel. But there's some split of authority or some split of opinion about whether that's what Monteo intended to do. Because if it's the case that Monteo got the lawyer without asking for it, does that make a difference to you? If the defendant had specifically asserted his right to Sixth Amendment counsel, whether or not that sort of reasserts the right to counsel because he asked for the lawyer. So think about those things. Love to hear what you have to say about it. I think that is all I have for this part of it. This, as you can imagine, is pretty intensive. And when you read the chapter for this, it's going to take a little bit of time and may generate a lot of questions. And I'm here for you. Like I said, just continue to communicate with me as you need to. But that's it for part 2. Thank you, folks.